what is the most important thing in this process that a legal practitioner has to do to protect their clients?
I think it all starts with preparation of the matter, Dinesh.
So what's involved in preparation? What do you mean by that?
Well, preparation for a criminal trial involves obviously getting all the documents first from the relevant parties. There's the disclosure requirements that the police has to go through, and then once you get all the documents, you need to thoroughly prepare the trial. You need to go through the witness statements, for example, and then you need to develop what we call a case analysis. You need to know why or how you're running the trial. What is the main reason you're running the trial?
I think important issues come up, what facts are in dispute and what facts aren't, and then, as Chen said, the strengths and weaknesses of our case and also that of the other side.
So preparation is so important?
Absolutely. I mean, preparation is important for the same reason that, you know, when you build a stadium, you don't just go in and bulldoze everything down and start laying the bricks or whatever it is that you do. You have to have a plan, because you don't know where one particular step or one particular question or one particular argument that you might make might seem good at the time, but might have negative consequences because of that particular transcript that you didn't read or that particular statement that you didn't look at thoroughly. So it's very important to have a very clear understanding of what's going on.
As a legal practitioner, I might add my 2 cents of worth. The art of rhetoric or the oratory skills, the judgment, the experience, the body language, the personality, all comes into play if you're representing your client. And a key there is preparation. So without preparation, you might confuse the witness or your client and the whole court system, the jury and the judge as well, isn't it?
Or yourself.
Or ourselves, yes. So when does the trial actually start?
Well, the trial starts essentially when the defendant or the accused, there's a number of different ways you can call them, they plead not guilty on arraignment normally, and when they're arraigned in front of a jury panel, that's when the process starts.
So let's start a criminal trial process. What happens?
Well, the judge will make, once the jury is impanelled, in other words, once the jury is chosen, and by the way, you can have as much as 15 jury members, or and that still count for potentially losing some along the way.
Right.
The judge will make some opening remarks, will explain to the jury what's going on. They will explain things like the presumption of innocence, that every accused is entitled to be presumed innocent until the evidence proves otherwise. They will explain, for example, and emphasise over and over again that it's ultimately for the jury to decide what happened. Whatever the judge may say, it shouldn't be taken as hinting or influencing the jury, that they are really the final arbiters of what actually happened and what didn't happen.
So it is the judge's duty to tell that to the jury?
Absolutely.
All right.
Absolutely.
So after the judge's opening remarks, then what's happened? Does the defense or the prosecution starts their whatever they have to do? How does that?
Well, then once the opening remarks finish, it's up to the Crown to first put forward their case. The prosecutor basically goes through his or her arguments and goes through the witnesses that's required to be called and lays down the prosecution case.
Sometimes the prosecution may also indicate at this stage that they're not going to lead evidence on particular charges. So the judge may discharge the jury on making a verdict or returning a verdict on that charge, and may say, look, enter a plea of not guilty, and then they'll discharge that particular charge and allegation.
So it's traditionally the norm for the prosecution to go first. So what they do in the opening remarks, or what's the purpose?
Well, it's not just traditional, it's absolutely necessary.
Right.
Because the burden is on the Crown to prove its case. The defendant can't start off by disproving its case. So it's utterly necessary. And in the opening remarks, which is before the point at which evidence is starting to be led from witnesses and so forth, the prosecution will essentially tell a story about what they are going to prove. And that's important because the jury might walk into the jury room without the faintest idea as to whether they're in a murder trial or in a theft
Exactly,
or
because
whatever.
no one knows exactly
Exactly.
what they're up to, isn't it? Yes.
So they need to have some understanding about what's going to be presented so that they can, I suppose, look for the right evidence and think about it the right way.
Yeah. Usually, the prosecution gives you a prosecution opening, and they follow that mostly to the letter. Because that's how they present their case. They've done the preparation. That's why we're saying preparation is essential. They prepared it, and they will then go through the prosecution opening, and that's essentially how the whole case starts.
So what is appropriate for the prosecution to do in this particular instance in the opening stages?
Well, it's probably better to tackle it from what's not appropriate to do. Usually they shouldn't really be using emotive or prejudicial language, being mocking or sarcastic, referring to evidence that's inadmissible. That's quite important in trials, and referring to the status of co-offenders unless, say, the defence agrees, and not commenting on the weight of evidence or having an argumentative approach to things.
So that's the prosecution. So what about the defence now? What do?
What does the accused do?
Yes.
Well, it's for the trial judge to then ask ask the accused really ask the accused's legal representatives what they intend to do, because they might form a view about the strength of the prosecution case, and there's another number of options that they might take. Yeah.
One of the key things that the defence would do to answer the prosecution's case is to call witnesses that bolster their case or bolster the way that they're going to present an argument. There's a few different ways of calling normal witnesses, but the most important decision that the defence have to do in putting forward their case is to decide whether or not to call the actual defendant or the accused to give evidence. And that's an art in itself in deciding, because sometimes calling the actual defendant to give to be a witness and give evidence might either sink your case or win the case for you.
I guess, is it a matter of just saying to the court that, there's no defence, there's no merit to the other side's allegations? Is it really that simple? Because by the sounds of it, there's a lot that's put into this process. I guess, what are your thoughts about that?
Well, it's not really... I mean, technically you could simply skip straight to the closing and say, you know what, we're going to call no evidence. We are so confident that the Crown have not proved their case that we can just tell the jury to find our client innocent, and they'll do that. But
you can never guarantee what the court's going to do, or the jury in this case.
Exactly right. You can't guarantee that, and if you have good evidence that is exculpatory, in other words, shows your client is innocent, then you may as well lead it. And so you're still in that sort of evidentiary phase. And can I add something to what Chen said before, which is the point about the art of whether you call your own client or not. I mean, I think there's probably a traditional view which is probably has less and less weight now, but the traditional view that you just never call your client. But in fact, there can be value in calling your client. The problem with that is that when you do, and you expose your client to the witness box, you expose them to cross-examination from the Crown. You can't just call your client and not allow the Crown to ask questions. They will be entitled to ask questions.
So in essence, you could open a Pandora's box if you haven't prepared the case properly, which just goes back to your point about how important preparation is, Dinesh.
Right.